Hey everybody, Graham here. So I got a hold of Amber Heard's designation of assignments of error document for her appeal. This is the document that lays out everything that she's going to try to tell the appeals court that the trial court got wrong. So this is what she's got here. So I figured I'd just go through these. I'm not a lawyer. You understand that. This is purely just reaction to these points. So none of this should be construed as in any way legal advice or anything along those lines. So anyway, comes now appellant Amber Laura Heard by counsel and designates the following as her assignments of error pursuant to Rule 5A:25. Number 1, the trial court erred in declining to dismiss the action on the ground of forum nonconveniens. I don't know what forum nonconveniens is. I do know that it's relatively common for when one side of a trial finishes their presentation, it's pretty normal for the other side to move for dismissal on the grounds that they didn't prove their case. And these motions are almost always denied. But they do happen, and I don't know if that's what this is, but if it is, that, I don't think that's got a chance of going anywhere. Number 2, the trial court erred in denying the supplemental plea in bar and ruling that the November 2nd, 2020 judgment of the United Kingdom High Court of Justice, Queen's Branch Division, Depp versus News Group Limited et al., blah, 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 does not foreclose Mr. Depp's claims. So what they're saying here is that they told the court that the fact that Johnny lost the UK trial should invalidate any claim that he has in this trial. And that's obviously not going to go anywhere for a number of reasons. Number 1, it was a foreign court. And number 2, Amber Heard was not actually a party to that suit. She was just a witness, so it's not, I don't think there's enough of a correspondence for them to find anything there to grab at. Number 3, the trial court erred in denying the demurrer and plea in bar as a ruling as a matter of law that the 3 allegedly defamatory statements in the challenged op-ed are A, actionable as statements of fact rather than non-actionable expressions of opinion, and B, actionable as defamation by implication. That really was a question for the jury to decide. The court can throw out jury verdicts if it thinks it needs to, but that really would only happen if it was absolutely obvious. So the jury determined that they were actionable statements, that they were in fact defamatory statements and presented as fact and so forth. So I don't think that one's going anywhere. Number 4, the trial court erred in excluding from evidence at trial the November 2nd, 2020 judgment of the United Kingdom. So this is another one referring to the UK trial. So again, same thing applies. Different country, different laws, different set of parties. Number 5, the trial court erred in excluding from evidence at trial A, medical records, including Ms. Heard's contemporaneous communications with medical providers such as Dr. Laura Anderson, Dr. David Kipper, Ms. Debbie Lloyd, Ms. Erin Falatib, Dr. Amy Banks, Dr. Connell Cowan, and Dr. Bonnie Jacobs, and B, Ms. Heard's communications with several third parties, including Mr. Depp's employees and Ms. Heard's employees, friends, and family about interactions with Mr. Depp, including reports of drug use, aggressive and abusive conduct, physical abuse, and her fear for her safety. So basically what they're saying is that they should have included text messages that she had with her various doctors and Johnny's employees. This, as we saw so many times during the trial, this has got to be just considered hearsay. The medical records that she was talking about are just notes, and they basically just report what she said, and that's hearsay. So, I'm not saying there couldn't be stuff that I haven't seen, but Andrea Burkhart has all of the unsealed documents on her website, and they've been there since the end of the trial, so there's no real, there's no records that you can point to and say these are compelling and they should have been included. All right, number 6, the trial court erred in admitting evidence at trial related to Ms. Heard's pledge to donate money to charity and evidence related to Ms. Heard's alleged abuse of third parties. Okay, first of all, she was actually arrested for abuse, so it may be alleged, but that's a pretty strong allegation. They wanted to exclude all the stuff about pledging, which this one I think you could make a decent argument for, because in theory, the pledge has nothing to do with the defamation. The place where I see a weakness is that the part of the pledge was designated for the ACLU, and the ACLU helped write the op-ed. So I do see a problem there. I think that stuff all went towards credibility. And as far as I know, that sort of thing is admissible. So I'm not sure. Like, if they've got a shot, I think this is one of the stronger ones. Number 7, the trial court erred in excluding evidence at trial of Mr. Depp's reputation as it existed prior to publication of the challenged op-ed and after the op-ed was published. So what they're saying here was that the op-ed couldn't have damaged him because he was already damaged. I mean, I think they did a pretty good job of showing that the op-ed actually did cost him, at the very least, Pirates 6. And I guess he was scheduled to get something like $22 million for that. So I think Amber got off easy on that one. But I guess that one's arguable. I couldn't say that it was, that it's just flat out nothing. Number 8. The trial court erred in sustaining an objection during the cross-examination of Mr. Depp to a question about the truth of one of the allegedly defamatory statements on the grounds that it called for a legal conclusion. So, Amber's team asked him a question. His team said, objection, that calls for a legal conclusion. Johnny is not a lawyer, therefore he should not be making legal conclusions, and I don't think anybody should be making legal conclusions on the witness stand. I think that's a no-no. And the judge agreed with the objection, and I don't know what their rationale for that is. I think we'll have to wait for the actual brief to see what the question was and what the potential answer was, and whether or not that actually does call for a legal conclusion. Number 9. The trial court erred in allowing Mr. Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. I have no real opinion on this one. I guess he suggested that the jury could find that other things she did were defamatory. I don't know. I don't know enough about this one to comment on it. Number 10, the trial court erred in allowing Mr. Depp to argue or suggest at trial and the jury consider whether the alleged defamatory statements in the challenged op-ed were republications of the statements the statements Ms. Heard made in 2016 in connection with a domestic violence temporary restraining order she obtained against Mr. Depp. So what they're saying is that one of the statements that he sued her over was something that she said and then was in the op-ed, which could be considered a republication. Okay. Think that was up to the jury, and I think they decided in Johnny's favor on that. I don't think they're gonna touch that one. Number 11, the trial court, which rejected proposed jury instruction CC, improperly instructed the jury on actual malice. Have to see the argument on that one. My understanding of actual malice from listening to lawyers was pretty much exactly the same as it appeared on the jury questionnaire. So I don't know. I think that's probably not going anywhere. Number 12. The trial court erred in denying the motions to strike and set aside the jury's verdict with regard to Mr. Depp's failure to prove publication by Ms. Heard of the statement, "I spoke up against sexual violence and faced our culture's wrath. That has to change." So they're saying that the judge should have set aside the jury verdict on this. And I don't see that going anywhere. 13. The trial court erred in denying the motion to set aside the jury's verdict with regard to Mr. Depp's... Okay, so this is so they're just going through and saying that the judge should have overturned the jury's verdict on these. And I don't think that's going to go anywhere because the jury is the arbiter of fact. As far as I know, courts tend to defer to juries quite a bit on stuff like that. Number 14, the trial court erred in denying motions to strike and set aside... Oh, that's the other one. Okay. Oh, with regard to Mr. Depp's failure to prove actual malice by clear and convincing evidence. I thought he did that. Number 15, the trial court erred in denying the motions to set aside the jury's verdict and in ruling that the jury's verdicts were in favor of Mr. Depp on his claims against Ms. Heard and in favor of Ms. Heard's on her claims against Mr. Depp were not inherently and inconciliably inconsistent. So what they're saying here is, because remember, Amber won one of her counterclaims and got awarded $2 million for that. What they're saying here is that the fact that she won on a claim and he won on all three of his claims, that those are incompatible. And that's kind of silly on its face. I mean, it's entirely possible that they can both make defamatory statements. And I don't see a problem with that verdict at all. Number 16, the trial court erred in denying the motion to set aside the jury's verdict and upholding the amount of the jury's damages award in light of A, Mr. Depp's failure to prove pecuniary damages, we all already covered that, B, the excessiveness of the compensatory and punitive damages awards. I didn't think they were excessive. Alex Jones just lost a judgment for almost $1 billion. That's excessive. This is not excessive. And that is it. So there you go. I think if she's got a shot, her best shot has to do with the pledges, the donations to charity, and the republication thing. So points 6 and 7, I think, are probably their best shot. Again, not a lawyer, could be completely wrong about that. But as I read this, I just going through these things and say, okay, the jury said yes to this, the jury said no to that. The judge said no to that because it was hearsay. The judge said no to that because it was prejudicial. So, I think the other 14 are kind of self-evidently not real things, but that 6 and 7 have a possibility. And as everybody on LawTube likes to point out, there's nothing guaranteed with a court. They could grab onto those and say, yeah, that was a big mistake and we need a new trial. Or not. My suspicion is not, but again, not a lawyer, not a judge, not really involved with the case. So there you go. Anyway, I hope this was interesting to you guys, and if you want me to do the filing that Johnny made, which is the same sort of thing, only his is much shorter because I think he's only got like 4 or 5 errors that he's trying to assign. But if you want me to do that one, let me know in the comments, or else if this was, you think, a big waste of time, let me know that as well. But I will talk to you guys in the next one. I'll see you soon. Graham out.